Good afternoon, ladies and gentlemen. It's your host, Elgin Martinez from the Immigrant Education Channel, coming to you with another informative video. This video is going to be about a Lebanese immigrant by the name of Mr. Nasrallah. Mr. Nasrallah had been ordered deported from the United States. In his defense, Mr. Nasrallah applied for what is known as CAT, United Nations Convention Against Torture. The Federal Court of Appeal denied Mr. Nasrallah's request for relief on the CAT. Mr. Nasrallah then decided that he's going to take his case to the Supreme Court, and on June 4th, the Supreme Court overturned the findings of the Federal Court of Appeal and said that Mr. Nasrallah's claim was right. That being said, ladies and gentlemen, this case is about, as I said, Nidal Khalid Nasrallah, a native of Lebanon, a lawful permanent resident, and also a college graduate with no criminal history. On November 11, 2011, the U.S. Supreme Court charged Nasrallah with 8 felony counts of receiving stolen property after he purchased 273 cases of stolen cigarettes worth $587,096. Nasrallah pleaded guilty to 2 of the 8 counts, ladies and gentlemen, and was sentenced to 2 concurrent 12-month prison sentence. The government then attempted to remove Nasrallah from the U.S. In response, Nasrallah applied for both a withholding of removal and protection under the Convention Against Torture, CAT. Nasrallah claimed in his application that groups such as Hezbollah and ISIS, whom he had prior run-ins with, would torture him should he return to Lebanon, because he belonged to a religious minority called the Druze. The immigration judge that heard Mr. Nasrallah's case determined that he was eligible for removal. Nonetheless, the immigration judge concluded that Nasrallah showed that he would be tortured should he be removed to Lebanon, and ruled that Nasrallah qualified for defense of removal under CAT, deferral of removal under CAT. The Board of Immigration Appeal confirmed the immigration judge's findings that Nasrallah committed crimes of moral turpitude, but reversed the judge's decision granting Nasrallah CAT protection. That being said, ladies and gentlemen, Board of Immigration Appeal also concluded that Nasrallah did not qualify for CAT protection because his prior encounter with Hezbollah did not constitute torture. Nasrallah then appealed the Board of Immigration Appeal ruling to the Court of Appeals for the 11th Circuit. The 11th Circuit upheld the Board of Immigration Appeal findings that Nasrallah was not eligible for CAT protection or for deferral of removal under CAT. The 11th Circuit also stated that it was jurisdictionally barred from reviewing Nasrallah's case. Nasrallah then petitioned the United States Supreme Court. On Monday, ladies and gentlemen, June 1st, the Supreme Court reversed and ruled 7-2 that the federal law provision governing deportation do not bar judicial review of a non-citizen factual challenge to CAT. That being said, ladies and gentlemen, under federal immigration law, during removal proceedings, a non-citizen who demonstrates a likelihood of torture in the designated country of removal is entitled to relief under the International Convention Against Torture and may not be moved to the country to that country. If an immigration judge under removal and denies cat relief, the non-citizen may appeal both orders to the Board of Immigration Appeal. That being said, ladies and gentlemen, we've come to the end of this video. Please share, like, subscribe, and hit the notification bell.